morning, everybody. It's 5 minutes after the hour. Francis has stepped away for just a second, but in the meantime, I want to welcome you all. Thank you for joining us. We are blessed today to have our partners at the North Texas Fair Housing Center, namely the executive director, Francis Espinoza, to talk to us about self-help tools for tenants. Uh, we're going to include, or Francis has included, template letters, issues about unethical landlords, um, landlord versus tenant scenarios, and when should you get an attorney involved. And so we're going to go over all those things. My name is Marty Mascari. I am a contractor under the North Central Texas Council of Governments for the Area Agency on Aging and the Aging and Disability Resource Centers, or ADRC, of North Central Texas. And like I said, Francis stepped away for just a second. Oh, here we go. That's right. Perfect. That's where I want to
I'm
go.
here. Are you ready for the next slide?
Yep, I am.
Okay.
Go for it. No problem. So for those of you joining us for continuing education units, we are set up to provide continuing education credits for licensed social workers and licensed professional counselors that are licensed in the state of Texas. We also have a certificate of attendance available to anybody who might want one. Today's webinar is worth 1.5 hours of CEU credits. Please know that a lot of people have told me they've been able to get the certificates, whether it's a CEU certificate or a certificate of attendance, and use them for CEUs for other licenses. And I've had a few, even the jurisdictions, email me, ask people for some more information on the webinar. And they've been able to use them, but there's no guarantee if they're not in Texas and they're not one of the two licenses, then there's no guarantee. But again, I've heard secondhand that there's other agencies that take them. In order to qualify, you must complete the entire live webinar and the Q&A. You must also complete the Google evaluation survey. This survey should pop up for you as you log out of Zoom today. It should give you a chance to go there. I think a screen comes up giving you the option to go there. So I know some companies and people have pop-up blockers, so no worry, you will also get that link in a follow-up email from me sometime tomorrow. The survey will be available until the 3rd of November to fill out, till 5 p.m. on the 3rd. And please give us about a month to get those certificates out to you. It does take a little while for us to get to those and get those out to everyone. That being said, I'm going to turn it over to Francis Espinoza, who's the Executive Director of the North Texas Fair Housing Center. Francis, it's all yours.
Thank you, Marty. How is my volume? Is it okay?
It's great.
Okay, good. Like Marty said, my name is Francis Espinoza, and I'm the Executive Director of North Texas Fair Housing Center. You'll see on the first slide there my email address. Email is always the fastest way to reach me. So take a note of that if you think you might have questions later on, or if you're someone who also assists clients like I do, and your clients have fair housing issues, you can contact me and I hopefully will be able to help. Okay, so one of the issue I want to start with is repairs, because that's one of the top reasons that people contact us at North Texas Fair Housing Center is, something is broken and needs to be repaired. For example, during the summer months, we get a lot of calls about air conditioning that isn't working. And, it can be various types of repairs. The general rule is if it's an emergency type issue, like a broken pipe, then the landlord or manager needs to get it fixed right away. If it's just a general repair, like maybe you have a drippy faucet, or what other thing is, it might be like a running toilet, might not be an emergency. Those things should be remedied within 5 working days. And so those are kind of general rules to keep in mind if you have a repair issue. So the first thing you want to do is always put your repair requests in writing. If your apartment has a portal, and they require you to put repair requests into the portal, put it in, but if the portal isn't going to give you a receipt, before you hit that submit button, take a screenshot with your phone so that you can show the day that you put the repair request in and what you requested. I think most portals do not send you any type of receipt or email you anything when you do a repair request. So just keep that in mind. And it doesn't hurt to also put your repair request in writing, even if you do it through the portal. If the management office will accept it in writing, I would also do that. So you need to make sure when you do this repair request in writing that you send it certified mail with return receipt, so that you have something that shows that it was sent and received by the management of the apartment or of the rental. And you can use US Postal Service or anything that will give you some tracking information. If you hand deliver the request, always take a witness who is over 18, so that you have somebody witness that you're turning over this written repair request, and have the manager acknowledge it by signing a receipt. And I have those acknowledgements on the sample letters that we'll go over. Okay, so this is a sample of a first repair request. So you want to put obviously the date, so that and it should be the date that you plan to hand it over, or the date that you mail it. Attention manager. So if you have the manager's name, then put that in there. But if you're not sure, just put manager and the address of the management office of your apartment. Put your name in there, that you are and your name, that you're a tenant living at, and the address, and then list the repairs that you want to have made. So in this case, the person's heating system is not working. The living room electrical outlet and the front door sparks and smokes when they try to use it. That is sort of an emergency repair if it's sparking on its own. If it's only sparking when you plug it in, when you try to plug something in, then obviously just don't use it, and maybe then it's not an emergency repair. Living room ceiling is leaking pipes above the apartment, and then cockroaches throughout the apartment, that it needs complete extermination. And this next sentence is really important, that you believe the conditions constitute a threat to your health and safety, and you would like them repaired or remedied within a reasonable amount of time. And then should you be unable to resolve the repair problem within a reasonable amount of time, I request a written explanation of the reasons for the delay within 5 days after you receive this notice. So generally, they should, within 5 days, make that repair. And if they don't, in this letter, you're asking for an explanation for why they aren't. I know when during COVID, AC and heat repairs were taking longer than normal because there were supply chain issues with some of the parts. So that would be an example of an explanation that would probably be reasonable if they sent you an explanation within 5 days saying, we want to fix your AC, but we're waiting on a part. The part hasn't come in yet. So we need more time, that sort of thing. And then you see here at the bottom, and then of course, sincerely, and then your name, and between the sincerely and your name, sign it. And then you'll see on the lower right, this is where you would enter all the information. So if you hand deliver this, you're always going to want a copy. So make a copy of the letter so that you can notate all this stuff for yourself. So if when you're sending it certified mail, you should have a tracking number, and that goes in the space right there. If you're hand delivering it, put the date you're hand delivering it, the witness's name, and then received needs to be signed by the person that you're handing it to. So, manager, if that's the person you have to make repair requests to, have them sign your copy. And then you have a signed copy acknowledging that you've submitted this repair request. So there's also a form you can use for this first repair request if you don't want to write a letter. There's a fill-in form, and this is what it looks like. So this one is essentially the same exact thing as the letter. You just, you can actually handwrite into this form the date, attention to the manager, your name, address, and then you can list your repairs. I only put 3 lines in here because I was trying to make this as big as possible so y'all could see it very well, but you can add as many, we can add as many lines as there is as you need. And then the next 2 sentences are exactly the same. Sincerely, and you could sign your name on that line, but I would also print your name underneath it so it's clear. And then it's the same fill-in information for your certified letter tracking number, if you hand deliver it, when the witness that you brought with you, that remember needs to be 18 or older, and then there's the received line for the manager to sign. So the next thing we're going to go over is, so say they don't respond to this first repair request. There's a second repair request that has a little bit different language in it. And the goal of these repair requests is that, the first one is just a general, like, I need you to fix this stuff. The second one, you're kind of ratcheting it up a little bit. And the end goal is that in Texas, there is a process where you can repair and deduct from your rent, or even terminate your lease without fees or penalties if they haven't made the repairs. But I don't ever recommend that, because in addition to doing these 2 letters requesting those repairs, you have to have other types of documentation. One important piece is something from code enforcement or code compliance that cites the landlord or the management, whoever, for having a condition that is, typically it's going to be a really bad condition that makes the apartment almost uninhabitable. And the code compliance will cite the apartment and give them a certain amount of time to make the repair. So I want to go back to the first letter where it lists the items. So on these items here, some of them do not rise to the level where code compliance would come and look at it and possibly cite the apartment. The one I want you to look at is the cockroaches throughout my apartment. We're all, like, I think, disgusted by that. It needs to be remedied. But unfortunately, code compliance, they don't care about roaches. There's nothing that they can do if you have a roach infestation. So that's an item that, is disgusting, right? You want it to be remedied, but you're not ever going to get code compliance to cite an apartment for that issue. The living room ceiling is leaking. Possibly they might cite for that. It really depends on whether they can determine why it's leaking. Electrical outlet, that's something they might. If sparks are coming in smoke when you plug something in, that clearly is unsafe. So that is probably something that code compliance would write up the housing provider for. Heating is malfunctioning. That, surprisingly, you might be surprised that isn't one that code compliance would write up for a malfunctioning heating system. Air conditioning, for example, during the summer, they might write that up if their city has an ordinance that says, for example, a lot of cities have ordinances that say if the temperature outside is 85 degrees or higher, and the air, the tenant has to have a working air conditioner. So if those circumstances exist, the air conditioner isn't working, it's over 85 degrees outside, then in that case, code compliance might cite the landlord. but you never know you never know if they're going to cite them or not. Even for the leaking ceiling, they might not give the landlord a citation. And that's one of the really important pieces of being able to get to the point where you can legally repair and deduct, or even legally terminate your lease without any fees or penalties, because the rental is just uninhabitable. And so that's why we never recommend it. That we never recommend that you should do that, because if you're not, even if you miss one of the steps, you won't be doing it legally by the process that's outlined in the Texas Property Code. And then if you say deduct from your rent, you'll probably be evicted for non-payment of rent. So you need to be real careful about that. Okay, so let's look at the second letter. So this letter is if they didn't respond to the first letter, or the repairs still haven't been made, then you can ratchet it up a little bit. So you're listed, the same first couple of elements of the letter. The first couple of elements of the letter are the same: date, management, and you'll see this one was written, the first one was November 1st, this one's November 10th. And then again, listing all of the same things that were in the first letter. Same statement about it being a threat to your health and safety. And then this last sentence, or this last paragraph, is the kind of ratcheting it up part. So should they be unable to repair the problems within a reasonable amount of time, that you want the written explanation. Should you fail to comply with this second request, I will exercise my rights under Chapter 92, Subchapter B of the Texas Property Code. I may terminate my lease and pursue judicial remedies, and or exercise my right to repair and deduct. So this letter, for me, the purpose of this letter is more like maybe put them on notice that this stuff really needs to get done. But I don't ever recommend following through on that repair and deduct thing, unless you can follow every single step in the statute for what for what the problem is that you're having. And then lower right corner, again, same, send this certified mail. You want to put the tracking number in there. If you deliver it, bring your witness that's over 18, and then have the management sign in the line for received. And again, if you don't want to do a letter, there's the same form that's fill in to make it easier. And so we just fill this in with the same information. It has the same last sentence about, pursuing your judicial remedies, and the same information for tracking is on the lower right. Okay, so are there any questions about this before we continue? Because I know that this is a lot of information to take in. Any specific questions about this? I apologize if you can hear my dogs. I'm at home and they're going a little cuckoo right now. I don't know why.
I do not hear them.
Okay,
so
good.
I think you're okay. But
Okay.
somebody asked how they could get a copy of today's Zoom meeting. The slides, I'm going to put it here in just a minute. They should have been sent out to you in the link with the link, but I'll get you a link for them in just a second here, where the fillable form's located. So what you're going to want to do is you should be able to copy and paste right off of the PDF that I send you. But if you can't, send me an email about that, and I'll try to figure out the solution for you.
Yeah, and Marty, if it helps, I can take them out of the PowerPoint and make Microsoft Word documents.
That would be perfect.
And send them to you, and that way people, because obviously they're going to want to not, no one's name,
yes.
No one's misread a tenant, right? So they're going to need to change that. So
if you will do that, that would be great. And then what I'll do is I'll just create links for each of the Word documents and send them all out together.
Okay.
Someone said they had reached out to you about about a mold issue, I think. But we'll,
So
we'll
someone asked, what is the point of submitting these letters if they don't help solve the problem? Well, we're hoping that with the first letter and the second kind of ratcheting it up, that your repairs will get made. But like I said, these are all going towards the, repair and deduct or terminating your lease because of, habitability issue. But again, you need to look at the statute and make sure that you're following every single step, because if they take you to court, if they try to evict you or they file an eviction on you because you left, you terminated your lease, or because you deducted from your rent, you want to be able to go to court and show the judge that you followed each step of the statute of the Texas Property Code. But, I never recommend this because, going to court is not ideal. And we have a lot of judges in Texas that, very landlord biased. And even if you do everything right, they could just make a bad judgment and make a judgment against you. So, I'm hoping that, these letters would help you because, landlords generally don't like when tenants put stuff in writing. When you start documenting things, they seem to take it a little more seriously. So, all this is in the hope that they would make the repairs that you need before you had to go an extra step.
Kayla, thank you for putting the slides in there. That's really nice. Thank you for putting that link in there. Someone asked if there was a way they could get a copy to the statutes, they could review it. And Christy, you're right. It's really trying to push them. I think the more formal you make your request, the more they're going to pay attention to it. Would you say that's probably true,
Yeah,
Francis?
yes, I agree. And remember, one of the reasons too that, we don't recommend this is all of your repair requests are very urgent to you and very important to you. But what if none of them rise to the level that code compliance would come out and do a citation of the housing provider? Then you're never going to get to that threshold of being able to repair and deduct, or of deducting from your rent or terminating your lease. So that's the reason why we don't, because I think, any situation like, I get people every day calling me about roach infestations, and well, not every day, but several times a month I get people calling me with roach infestations, and the housing provider is not doing any kind of remedy for it. They're not doing any kind of extermination. And it's just an awful way to live if you have a roach infestation. But roach infestations don't rise to the level that code compliance would come out and review and inspect. It's just not an issue that they inspect for. There's no, cities don't have any codes related to insects or roaches. So, and if that's your only issue, it's horrible, and it's really, it's a real drastic thing for you. I understand that, but it's not something that code compliance would ever come out and look at. So,
Francis, do you know if is there an online forum like Yelp or somewhere where tenants can post their reviews of the property of the landlord that would stay out online, or they could check a property before they move in?
yeah, I think it's Yelp, isn't it? I mean,
there's Yelp. I
yeah,
didn't know if there's somewhere else.
there's nothing specific to rentals. So,
That's what I was wondering.
but I've had a lot of clients post things about their apartments on Yelp, and if there's, issues, and, you just have to be really careful, because I've also had clients be retaliated against because the housing provider finds out
Yes.
who made the complaint online, and then they'll do things like give you a poor reference if you're looking for another apartment. And then, no one wants to rent to you if you have a bad reference from an apartment. And so you have to be real careful about that.
Stephanie, make sure you've got that approval to rent in writing. That's very important. But I'll let you. I'm going to stand by and let you finish. Sorry, Francis.
Okay, no worries. Let's see, what did I do that? There we go. Okay. So the next thing I want to talk about is requests for reasonable accommodations. And this is the most common type of discrimination issue that we see at our office. And I think some people know that they have the right to request a reasonable accommodation, and some folks don't know. And, sometimes even if they know, and they've made their own request and it's not being taken seriously by the housing provider, that's something that we can get involved in and become your advocate and try to get that accommodation for you. So under the Fair Housing Act, people with disabilities are entitled to accommodations so that they can have equal use and enjoyment of a rental. And that's equal use and enjoyment as compared to somebody who doesn't have a disability. So accommodations specifically are requests to change or be exempt from rules, policies, or procedures. Because there's also another area called reasonable modifications, which are changes in the physical structure that I'm not going to really focus on, because the modifications area is something where, the tenant can request a modification, but in most cases, the tenant has to pay for it. And that ends up being the barrier, not the permission from the landlord isn't the barrier. It's the fact that, landlord knows the law and knows they don't have to pay, and tenant then has that barrier that they can't afford to make it. Now, accommodations, like I said, are changes or exemptions from rules, policies, and procedures. The most common request that we get is for emotional support animals, or ESAs. And it's folks who want to either not have to pay a pet deposit, which they shouldn't have to if it's an ESA, an emotional support animal, or if the apartment has like a monthly added pet rent of, I've seen them be $25, I've seen them be $50 a month, and they want to be exempt from that. Or they want to have more pets than the apartment allows. So maybe they only allow one pet and the person has 2 ESA dogs or little dogs, or 2 ESA cats. And emotional support animals, they can be cats, dogs. I've also worked with folks who have had birds. And I feel like I've helped with one other one, but cats and dogs are obviously the most popular. But I have done a fair number of requests for birds, to have birds in their unit. So some other examples of things that can be requested are terminating a lease early without being charged any fees or penalties. And that could be for someone who maybe lives in a 2-story apartment. They're on the 2nd floor, there is no elevator, and now they're having mobility issues and they just can't negotiate the stairs anymore. So they could either ask to transfer to a 1st floor unit, and if one isn't available, they can ask to terminate their lease without any fees or penalties, so they can find an apartment that's more accessible to them somewhere else. Other examples are getting a parking space closer to a unit, getting an assigned parking space, for example, or, even asking for not an assigned space, but asking them to designate more spaces as handicap accessible. Changing a rent due date is an example, and allowing a caregiver to live in the tenant's unit. Those are all examples of things folks can ask for. But and these requests are really, we analyze them on a case-by-case basis, because what's reasonable at one apartment might not be reasonable at another, and what's reasonable also may not be exactly what the tenant wants, but there may be another reasonable alternative that suits, that fills the need for the accommodation. Okay, so sample letter that someone can do on their own, really easy. The date to the manager, and you put the manager's name, the address, and then you put your name. I'm a person with a disability as defined by the Fair Housing Act. As a person with a disability, I have the right to request a reasonable accommodation for my housing. I request that I be exempt from paying a pet deposit for my emotional support animal Scooter. I have attached a letter from my doctor that prescribes Scooter for my disability. Sincerely, and your name. Now, the apartment doesn't have to ask you for a doctor's letter, but it is their right to. So we always tell tenants to get that ready right away and be prepared to give it to the apartment if they request it. And so you'll see in this letter, I just, automatically gave it to the apartment, even, I don't know if in this situation they wanted it, but it's always good to have it, be prepared with it, so that you could turn it over right away, so that you don't have any delays. Because essentially, if you don't have that and they have to ask you for it, that's a valid reason for them not to take action on your request until you provide the documentation. So that's why we always say get it ready and just submit it with the accommodation request. It's just a lot easier that way. Okay. So unethical landlords. So one thing to be aware of, and if you've attended any presentations that I've done before, you know that there aren't many laws in Texas that guide the landlord-tenant relationship, because Texas is a very pro property owner state, and because of that, most of the elected officials, they don't prioritize tenant rights. And so even when there is new legislation proposed, it most times doesn't even make it out of committee so it can get voted on. It's like quashed in committee. So we need to elect more people that care about, and if we want more laws that are helpful to tenants or talk about tenants' rights, then we need to elect people that care about that issue. So for all of these unethical landlords or landlords that don't follow the law, tenants' recourse is Justice of the Peace Court, or JP Court. That's what Texas calls, what I think most other states call, small claims court. And so Justice of the Peace Courts have jurisdiction in civil matters that are not more than $20,000. So up to $20,000, and you could take your claim to JP Court. Now, JP Courts, you have to file at the court that's closest to where your apartment is, or you have to file it in the city. So the JP Court needs to be in the same city that your apartment was in. I'm not sure if just keep in mind, a lot of my examples are going to be from Dallas County, because they had a lot of forms accessible online that I could share with you. But the forms are going to look really similar in all other courts. So, there's not a lot of creativity there. But you'll have to go, and I don't know if Dallas County, they might, I'm not sure if they actually, if you file in a specific court, I'm not sure if that court hears it, or if they have some rotating way of assigning cases where, you'll still get a Dallas County judge to hear it, JP Court judge, but maybe not in the one that you filed in. I'm not sure if they do that kind of like rotating assignment thing. Okay, so a lot of examples of how tenants need to go to JP Court to enforce their rights. First example, tenant's apartment was flooded by a broken pipe. She had to stay at a hotel for 5 days until the pipe was fixed and the damage it caused was remediated. The apartment should pay for the hotel, but they won't. So the tenant, in order to get her money back, the tenant has to file in Justice of the Peace Court and claim the amount that she had to pay for the hotel. That's the amount that she wants to be reimbursed. So that would be what we call damages that she would list in her JP Court filing. for all of these things, look at your lease, read your lease first to make sure that there isn't anything in there that you can try to bring to your housing provider's attention. Like maybe there is some sort of provision in your lease that says, if the apartment is deemed uninhabitable and tenant has to find other lodging, apartment will either, not charge for those days of rent or pay for, suitable accommodation. So, check your lease. There might be something in your lease that talks about the situation you're dealing with. But if not, you have to go to JP court. And again, that's the only way for a lot of issues related to the landlord-tenant relationship. That's the only way that tenants can enforce their rights, is to go to JP court. Okay, let's look at the second example. The tenant moved out and received a letter that the apartment used her entire $1,000 security deposit for repairs. She said she stated that she left the apartment in excellent condition. So if she wants to get her deposit back, she has to file in JP court. So there are a lot of issues with this item. The first one is, a lot of questions to ask. The first one is, did the housing provider follow? There is a law related to security deposits, surprisingly, and it says that the landlord has to, within 30 days of the move out date, has to either reimburse the security deposit or send an itemization of what they spent it on, or a combination of the two. So in this case, it sounds like she got an itemization of what they spent her $1,000 on. But the important thing is, did she get it within 30 days? Because if she didn't, and they didn't follow the law, she might be able to ask for even more than the $1,000 back. But say they did, they followed the law and they sent her this itemization, but she feels like some of these things are really unfair. Like they charged her for, putting a hole, repiping or replumbing the whole kitchen sink area, for example. Should that have been something they did? Did she really destroy the entire kitchen sink piping or plumbing? Or did they just do that because they were trying to do some upgrades for the next tenant? So that may not have been something that she should have been charged for. So you'd have to look at the itemization and see what they charged you for. And if you feel like any of those are unreasonable, you would have to file a claim in JP court to get your money back. And so that's, the unfortunate thing, because, when you file in JP court, there is also a filing fee. You can ask for that back, but also remember it's your time. And so you have to be able to, attend the court date, and they don't consult your schedule when they assign the dates for the hearings. So you might, have to miss work or take time off. And so, there's a lot of other costs involved with bringing a claim to JP court. Okay, let's look at the third one. It's the middle of the summer and the tenant's AC stopped working. It's been 2 weeks since it stopped working and the apartment still hasn't made the repair. Tenant decided to call an AC repair company and pay $500 to get the AC repaired. So in order for the tenant to recover the $500, they have to go to JP court. The tenant can ask for a daily rate equivalent to the daily rent rate to compensate him for going without air conditioning. So for the amount of days, if it wasn't working for 2 weeks, you can do, divide your rent by 30 days and find out what a daily rate is. And for all the days that the AC wasn't working, you can ask for those damages plus the $500 back that you paid for the AC repair person. But I don't ever, in this scenario, the person should continue to pay their full rent, and they have to take this matter up separately with the JP court to get their $500 back and to get any kind of compensation for the AC not working for as long as it didn't work. So I would never recommend, unless you have a written agreement in writing that it's okay to deduct the $500 from your next rent payment, don't do it. Keep paying the full amount of rent. And then you'll have to take the landlord to JP court to get your money back. See, and in these three scenarios, I think you can recognize more and more that, the burden is really on the tenant. If they want to enforce their rights in Texas, they have to go to JP court for everything. If the landlord doesn't want to do what's right, then the only recourse is JP court. So, we get calls every day from people who are really upset about the conditions of their apartment. And they, I think they think that there's some sort of administrative body or government entity that oversees apartments, and there's nothing that exists like that. There's nobody that, is like a watchdog on these apartments. So, tenants are only left with having to go to JP court if they want to enforce their rights, which is really, really unfortunate, I think. Okay, so now I want to go and show you some of the forms. So typically in small claims court or JP court, it's literally just one page that you need to file. And so this is one, again, keep in mind, I pulled this from the Dallas County website, Dallas County Courts, and this is their petition for a small claims case. So the tenant, all they need to do is fill this out, and then submit it to the court with whatever the filing fee is in order to be able to get a court date. Keep in mind that you also have to serve it on the other party. So the party that you're suing has to be served, and you yourself can't hand it to them. In most cases, you're going to have to hire somebody, a process server company to do it, or the court will offer you to be able to pay a fee to have the constable serve it for you. But that has to be done. So you have to make sure that that's part of the process that needs to be complied with in order to be able to get a small claims court hearing date. Okay. And then this is a separate form that they had if you have, if one of the reasons that something happened to you was based on the fact that you weren't around because of military status, this is an additional form you can file, but this probably isn't relevant to everyone. I just wanted to show you that, this is another form they had available to put with your filing. And then here's another example. It's a case information sheet that you might have to fill out in addition to the one-page claim form. And in this case, you see under number 3, eviction. That's what landlords file, right? If you're filing to get some money back from, or to sue your landlord for some damages, you would check the box small claims in the lower right-hand box. And JP court is, like I said, the same court where landlords bring cases to evict tenants. Okay, so here's an example of what the fees are. And again, this is Dallas County, so I'm not sure if the fees fluctuate from county to county. I think they're set by each county. So, if you want to know the filing fees for the county that you're in, go to the county website and the courts page, and you can hopefully find all this information there. But in this case, you see that, just the filing is $54, and then you can pay another $80 to have it served. So if you pay that $80 fee, then the constable would serve that to the opposing party for you. Okay, and then there's all these other fees that probably won't apply to your case, but a lot of people don't realize that if they're if they get an eviction filed against them, it'll be heard by the judge, but if you want, you can ask for a jury to hear it, and then you have to pay this $22 to have a jury. and then your case gets postponed because they have to call up a jury for you. And so that would prolong the date of your eviction hearing.
Francis, do you have any recommendations as to what you would prefer,
For what?
judge or jury, if you were going to court?
No, I don't really. I mean, the thing with juries is people there's pros and cons to both, right? Like the judge is supposed to know the law. So if you're concerned about, the law being followed and you feel like, from a legal standpoint, your case is really strong, a judge might be okay. Some people feel like a jury might be better in some cases because the jury can sympathize with the person and, might be more sympathetic, right? But juries don't always follow the law, and that can cause problems too, right? So there's pros and cons to both, I think. So if you are low income, you can also get a waiver of both the filing fee and the service fee. So they'll waive the fee for the amount to file, and then the $80 that you would have to normally pay to have the constable serve it. You can get that waived as well. And it's a 2-page form that you have to fill out to get that. So all of this here, and then you'll see you have to submit a lot of information about your income. So you'll see under number 3, you have to report if you are on public benefits. And the second page actually has, different, you have to say what you pay for rent, your bank account information, list your vehicles. I mean, there's just a ton of stuff that you have to put on this form. You don't have to submit any backup documentation though, but you do have to certify at the bottom. You're certifying by signing it, you're certifying that you're submitting all truthful information. So, just keep in mind that, if they wanted to, the court could ask you for documentation, but it's not required that you submit it with the form. Okay, in every court in every county, with the JP court, they should have this fee waiver form. It might look a little bit different, but they all should have it, just like they will all have the filing form as well. It just might look a tad bit different than what I'm showing you. So for JP court, you can represent yourself. You don't need an attorney. So you can bring affirmative claims, and you can also defend yourself or present yourself, for example, in an eviction. So just make sure that if you're in an eviction, that you do not miss your court date. And you can call North Texas for Housing Center or legal aid to find out, how you can form the best case for yourself. And you really should do that and do it, quickly before your court date, because, for any kind of JP court, I don't know if legal aid will help you they won't help you bring affirmative cases. I'm not sure if they'll give you any kind of advice or information about it, but, you can call North Texas Fair Housing Center, and we'll at least give you some information about how you can prepare yourself if you're going to bring, say you're going to bring a JP court action to get your security deposit back. Things that we'll tell you to do is hopefully you took pictures before you moved out so you can show the condition of the unit. So I always recommend, before you move into a rental and before you start unpacking your stuff, take photos of everything. And then when you move out, after you move all your stuff out, take photos of the whole apartment again, so you have something to compare how it was when you moved in and how you left it. Those are really important pieces of evidence for security deposit claim. And then, we can hopefully give you information on other types of evidence that would be helpful if you're bringing any other type of justice of the peace court claim. Okay, so when to get an attorney involved. Now, this is really a difficult topic because it is not easy at all to get a private attorney interested in a landlord-tenant case unless you can afford to pay them. So, your rights may have very well been violated, but it will probably be really difficult to find an attorney to bring a case for you, because these are cases, and there's several reasons why. One, they're not big money cases. Number two, the damages that you're seeking probably aren't going to be, economically attractive to an attorney, because, typically if they're going to take a case, they're going to charge you an hourly rate for them to take your case, unless there's, the future shows that there could be a big damages award that they can take a piece of, and if you're trying to sue your landlord to get like, $500 back for fixing the AC and another $1,000 for not being able to live in your apartment for 2 weeks, that's not going to be appealing to an attorney. It's probably not going to be, it's going to be really hard to find an attorney to take that case unless you can pay them outright to take it. Cases they might be more interested in are cases with multiple tenants. So if it's it's a building, the whole apartment building is dilapidated and it really is not livable, everybody's having issues, you might be able to get an attorney involved if you can bring more tenants to the table and show that this has, a wider impact. So a widespread habitability case might be interesting to an attorney. And then also keep in mind, if you get injured on the property and you were injured because of something the landlord should have fixed but didn't, you might have a personal injury case. And those you probably could find somebody to represent you, because those are going to be cases that an attorney will take without being paid up front, because they'll take a third of whatever damages you get. And say it might be appealing to them if, the damages you're asking are, $50,000, for example, because they could take a third of that. So I just want to make, it really clear that, a lot of folks call us and, they want legal representation, but, in these types of matters, it's just really hard to get an attorney, for the person who it's happening to, it is the most egregious thing, and you feel like, what's happening to you is super important, and why wouldn't an attorney want to help you assert your rights? But, back to reality, right? The reality is they're not going to take it if it isn't a big money case. Okay. And if you need assistance, you can email or call. But I do recommend, if you need help, to email me, because that's the quickest way to get a hold of me. And then, do we have any other questions, Marty, before we?
There are several different questions. So,
Okay.
Is it Kedra had said that legal aid does assist with affirmative cases in legal aid in Northwest Texas. I'm not sure. That's just a comment made.
Okay.
Which direction do we go? Property owner did not disclose that there was a flood or water damage in the home.
Well,
and they're asking what direction to go in, that it wasn't disclosed before they rented the home, I guess.
Okay, so, you can take the owner to JP court for not disclosing that, but if there was damage related to what, the fact that they didn't disclose it. So, for example, was there something different you would have done if you had known that? Or did that, is there now a lot of mold, for example, because of this past flood in the apartment that you didn't know about, or past water damage that you didn't know about, and now you're having to live in that condition? So you have to just show what the damage what damage have you experienced because it wasn't disclosed to you? And you have
Lin-
to quantify that, right? Like, what is that in monetary amount? What is that?
and document it. Yeah. Do you have
Mhm.
receipts? Do you have um, Lindsay asks, if you end your lease early due to code violations, do you get your security deposit back?
You should still get they still have to handle the security deposit the same way that they normally would. So 30 days after move out, they need to either refund it or itemize what they used it on. So, and
Um,
the statute, you have to still give notice that you're going to end your lease because of all of these repair issues that weren't dealt with. And so, there's still going to be that notice requirement that you have to give. And then there's still that 30-day requirement after you move for them to refund the deposit or send you a list of what they used it on.
Make sure that you remember that you have to provide them with the forwarding with an address for them to send your security deposit to at the time you turn your keys in or whatever. Is that right, Francis?
Yeah, thank you, Marty, for bringing that up, because if you move out and don't give them a forwarding address until 10 days later, then at the time you give them the forwarding address, then the 30 days starts ticking. So if they then don't give it to you within 30 days of move out, and you take them to court, their defense could be, well, we didn't know where to send it until, you didn't give us a forwarding address until 10 days later. And they could have a valid defense to your JP court claim.
So Christy asked, if you're late on November's rent, can they require you to pay December's rent due to being late? I guess you're saying December's rent at the time you give them the November's rent and the late fee. I'm assuming.
Yeah. So, I mean, here's the thing. They shouldn't do that, but there's no law that says they can't do that. It would be really odd for them to do that. Like, you know, who, is going to have 2 months rent available, at the same time? Like, that's economically, that's going to be really difficult for a lot of people, but again, what they do and what they should do are different, totally different things. Like, they shouldn't do that, but legally, there's nothing that says they can't.
Um,
Sorry, I don't have a better answer for you, but this is again what we're left with in Texas, right? Like,
yeah.
landlords can pretty much do whatever they want. And that's why, if you want to assert your rights, you have to go to court.
I really say this every webinar, every clinic we do on housing. Please talk to your local representatives and give them what you think is important. If you think, what issues do you think need to be changed in the law, especially the holding a landlord accountable, right? Holding them accountable so they don't follow the rules. Who's going to crack down on them? So those are things you want to make sure you talk to your public officials, elected officials about. They've got to know that it's important to you. So hopefully enough people tell them, and then it becomes important to them because they do need to get reelected at some point, most of them. Internet talked about always doing a walkthrough with the video. In today's day with phones, with cell phones having videos and cameras on them, it's really pretty easy. Obviously you don't want to lose those pictures, especially the pictures of when you moved in, so that you can access them 2 years later. You want to put them in a place where they're not going to get deleted. But it's pretty easy to take pictures or video of the place these days upon move in and move out.
Yeah. Yeah. Pictures or video. And, I'm really bad at keeping that stuff on my phone if I don't need it, and then I delete it and forget. So I always keep emails though. So, if you take photos or video, email it to yourself
Yeah.
and it'll always be there in your email.
Um, and no a walkthrough with the landlord is not mandatory unless they require it. Is that right, Francis?
Yeah, yes, that's right. It's not, it's something that you could always ask for, but it's, not something they have to do for you. They don't have to do a walkthrough with you. Unless the lease says that. But if they're using the Texas Apartment Association lease, which most apartments do, it doesn't say in there that you have the right to a walkthrough or schedule your walkthrough upon move out. So you can request one, but they don't have to do that with you.
I need to acknowledge Mary, who also acknowledged us, but who took it upon herself. She went to JP Court and she won. She just posted in here that she won her case that we talked about.
Oh,
Um, yeah, and
yeah, that's
that's great.
awesome.
That's congratulations. That's really good stuff. Um, you guys, it can be done. It
Yeah,
can be
and
done.
and I'm glad the person said, let us know that legal aid can help with affirmative cases. So that's good to know because a lot of times, you can get yourself really, if you're going to represent yourself, you can get yourself really prepared. So, contact them or us and, we'll, advise you on what you need to do to be prepared, what evidence you need to take to court to make your case stronger.
Um,
Anything else?
Someone asked about, Melissa asked about, I'm sorry, I'm just slow about going through these. What about com, um, I'm assuming a competing accommodation request. In other words, a bird accommodation in one unit and a person with a neurological sensitivity to sound in another, and that the bird screeching in the unit is a nuisance.
Okay. So, accommodations are specific to the person. So, the person with the bird, it could be a pet. We don't know, right? It could be an ESA, but it could just be a pet bird. And if the apartment allows that, then they just might have that. And the person in the unit next to them has a sensitivity to sound. So that person needs to request an accommodation that suits that person. So they can't, for example, ask for an accommodation for the person next door to get rid of the bird. The accommodation has to be specific to them. So a reasonable solution might be that person asks for a transfer to another unit. So
Going going bird hunting is probably not the best solution to that.
no,
I'm sorry.
yeah,
Terrible.
I'm sorry. And I was thinking of, I was not thinking when the people I've helped with birds, they have not been big birds, they've been small ones. So I have never done, for example, an accommodation ESA request for like, I don't know, a toucan.
Somebody asked if what if they need a first floor unit, but they're already behind in their rent? Can they still request an accommodation?
They could still request an accommodation. It's going to be a little bit more difficult to get it if they're not current with their rent. So, that's the rub. If they, to ask for any of your rights, it's, always better to have your rent paid up to current.
The one of the things I was going to say earlier, and I apologize, but about the pictures and the records. What we constantly see, even on our clinics, is people don't think about that stuff until 30 days after they moved out, and they get the letter from the landlord, and the landlord said the place was a disaster, and they spent all your security deposit to clean it up, and that's when you need the pictures, and it's too late. So you've got to be proactive in getting those pictures on move in and again on move out. As Francis said, before you move your stuff in and start unpacking, um, you want it of the empty apartment, and then after you're all done moving out and everything, go in and take another set of pictures or another video. But you got to be proactive on that. Once you get behind the eight ball on that, you can't go back and fix it.
Yeah, and you know what I find, Marty, with a lot of the people who call us, they've been really good about taking pictures of how they left it, but they forgot to take pictures when they first moved in. And so there's nothing to compare it to.
Yeah.
So remember, take pictures when you first get to the apartment, even before any of your boxes are put in. And then again, take photos after everything's removed and the apartment is completely vacant.
I can tell you, my son, I've got my kids all doing that at their college apartments because it's so important. But my son got stuck on a old grand piano that was left in the garage by the previous renters, and they charged them after they moved out for hauling it off when they had told them they were going to haul it off when they moved in. The landlord did. So and what do they do then? They don't have anything in writing to document.
Yeah.
Um,
So everything always in writing. Like I'll give you a really good example. I deal with people every day who, they call and they're upset because something popped up on their credit report that they didn't know about. And it's because, 8 months ago, they were sick and tired of their apartment. There were things that were wrong with the apartment. Maybe there was repairs that were needing to be made. Maybe it was, full of insects, who knows? And so they went to their apartment and they had made requests for things to be repaired or dealt with over and over and over. They felt like they weren't being listened to. They go in one day to their manager and they, just, they tell them how disgusted they are and that they just, they want to move out. I want to move out. Can I move out? And the manager will say, yeah, you can move out whenever you want. And then they move out. Now that is not permission to terminate your lease early without fees or penalties. Anybody can breach a lease and move out whenever they want, but look at your lease. There's going to be a section there that's going to talk about if you don't live, to the end of the lease term and you want to leave early, oh, by the way, you're going to owe us the equivalent of 2 months rent and a reletting fee of $300. And so, you can always breach your lease if you're willing to pay for it. But
Stephanie,
going
Stephanie,
into
I
your
really
manager
point.
upset and your manager saying, well, then move if you want to move.
Yeah.
You okay?
Stephanie, I encourage you to make sure. I see that you said you've been given permission to move without fee or penalty, but just make sure you have that in writing. That's got to be in writing. You've
Yes.
got to have a
So that's the
documentation.
thing, like, your landlord yelling back at you or the manager yelling back at you, well, move if you want, then go ahead, move out. That is not like, you need to get in writing that you have permission to move out without fees or penalties. Okay. Otherwise, that will happen 8 months later. You'll get something popped up on your credit report that you're in debt to your previous apartment, like, I don't know, $2,500.
Lindsay asked, how do you get code compliance to come out? And that's going to be primarily if you live within a city limits. It's going to be calling your city code department and asking them, telling them what the situation is, and seeing if they will come out. But you can also call the health department. In general, Texas is, as Francis said, a very landlord-friendly state. But there may be cities and counties that take, or even just judges that will take a little bit different approach to that, and may have been burnt, so they may be willing to help you out. So I would check with them and ask them what the situation is, or tell them what the situation is, and see if they would come out and inspect. Is that fair enough, Francis?
Yeah. So the code compliance is always it typically is a city department. And so call your city, the city you live in, and ask if they'll come out and inspect it. If it's something that and then you'll be able to find out if it is a code compliance issue that the landlord could be cited for. And if it is, they'll come out. If it raises to a certain level, they'll give the landlord a citation saying, this is the issue, this is what you need to do to fix it, and this is the date by which you need to tell us that you fixed it or show us that you fixed it. Um,
Stephanie?
so I think people were asking about, because I did not go over the process for the repair and deduct or terminating your lease because of repair issues or health and safety issues that um, the young lawyers section of the Texas bar, they put out a really good handbook that has all of the tenants' rights information for Texas. Because all
I
those
will,
state
I,
property.
I'm sorry. I'll include a link to that in the follow-up email. I'm sorry.
Yeah, and I have it on my desktop. I can email it to you, Marty. And that's a good resource to have, and it's free. It's online as a PDF. That's what I'm going to send to you, Marty. But that has everything in it for the state of Texas.
Um, oh, someone asked where they can find the code. Well, that gives you the thing. Um, Kelly asked, I had a client um, that has won his case a while back. That's great, Kelly. That's really good. Any suggestions on how
So,
to collect judgments once 21 days appeal date passes?
so that's the other step that I didn't talk about, which is, you take your landlord to JP court, you win. They owe you now $2,000. They may not just willingly pay you, even if there's a judgment out there. So you might have to work to enforce the judgment. And that's a whole other step that I don't know. I don't know a lot in detail about it, but one of the things you might have to do is, hire a collections agency to try to get you that money. And if you hire a collections agency, you're probably only going to get a percentage of it, not the whole thing.
You have to have an attorney to put a lien on someone's property.
I think you can do that, put a lien on yourself, but that's again another, in order to do that, that's goes through the county, because it's the county that has all the property tax records and all of that. It's probably easier if you do have an attorney assist you, because to put a lien, I think you have to file something in court.
I see. I see. But
Yeah, so
a lien is usually how and a lot of times a lien on their property won't affect them until they go to sell or they go
right.
to refinance or something like that. But then they'll have to cure the lien in order to be able to get a title policy for the new owner or for the mortgage company that they're refinancing with.
Right. So if you file a lien, you're not probably going to be waiting a while to get any money from it.
Um, what
The
if
other
the
thing too is
landlord?
I don't know if they have a process here in Texas, because when I was in California, we did put liens on people's properties when they lost they lost to us a fair housing case, and they tried to ignore it the whole time, and then we got a default judgment and then put a lien. There is a process with a lien that you eventually could force the sale, but I don't know if you can do that in Texas.
Yeah, yeah, I would imagine. I mean, I know you can't on their homestead, but I would imagine on a income producing property, there's probably
Yeah, maybe. I don't
something.
know. Yeah.
Yeah, yeah. What if the landlord asked you to sign? I'm assuming um, um, that you're talking about sign the itemized return deposit in order to get the little money they're giving you back. Is that valid? Can they pressure them to have to sign, agree to the list that they're giving them in the letter? But you don't
And
have to do that, right, Francis?
you don't have to do that, but I guess they could say, sign off on these repairs and then we'll give you the rest, we'll reimburse the rest, and that make that a requirement. But, you know,
But
again, they could do whatever they want, but if that exceeds the 30 days, then they're going to be breaking the law by not doing it within the 30 days. If they're
so
waiting
would
for you
you?
to sign something that you don't have to sign.
Yeah. So would your suggestion be there just to not, they've got to mail it to you, right? If you've given them a foreign mail address, and if they keep calling you to try to pressure you to sign, would you just ignore the calls and because if they don't mail it to you?
Yeah, I mean, I would take case by case and see if
Yeah.
it's, is it worth it? Is it worth your time to, pursue a JP action for it? Or are they giving you enough of the deposit back that you're happy, call it a day and be done with them? So it really depends. But if you're unhappy with what they're offering you, then don't sign it, because if they're going to use that signature as, the only way that you're going to get the check for the difference, and you don't agree with it, don't sign it, and they'll exceed the 30 days, and then you could take them to court for
Yeah.
not abiding by the statute.
Just the fact that they're trying to get you to sign that in order to get your money back raises some red flags, I think.
Yeah, it's not illegal though, but it does raise
Yeah.
some red flags, and I don't know why they would do that, because if you don't willingly sign right away, it's going to eventually exceed the 30 days they have to get you the deposit back.
Yeah. Jose says if it's not in black and white, it was never done. And Kayla basically talks about if it's not documented, it didn't happen. Absolutely. Someone put on here that 311 is the number to the city of Dallas code compliance, but I don't think that would be the same in all the cities, would it, Francis?
I don't think so. I mean, 311 is, you can get connected to any city department in Dallas if you call 311. For the smaller cities though, you just, look up their website, and they should
Yeah,
have a page for code compliance that'll have the phone number. Or
yeah.
sometimes they have a form online that you could submit with your code compliance request.
Hmm. Okay. Achille, uh, I think it's Aquila asks, I live in a supposedly handicapped unit. There are only two handicap parking spaces in my breezeway of a three-story building. There's not an assigned parking to go with my apartment. I have COPD, um, fibromyalgia, a few things, a bulging disc. How can I request either additional handicap parking or one assigned unit? I'm assuming, yeah, or an assigned unit, a parking spot.
Well, the first thing to do is use that letter from the accommodation request slide. Use that sample letter and adjust it for your situation, and put in there what you're requesting, and that's the first step. And then if they don't allow your request, or they ignore it, then you can contact us to get involved. But you can take the first step on your own by doing that accommodation request letter.
Um, okay,
And
that's a very,
be really specific with what you want. If you want, there just to be additional spaces marked as handicap, but it sounded like you wanted to have one assigned to you.
yeah.
So, make that request.
Um, the kid asks, goes on to say she lives in a complex in Carrollton, Denton County, but I vote for Dallas mayor and Dallas police. And Dallas police come out instead of the Carrollton police. Um, there's something not right there, but I don't know if did you re-register to vote when you moved there into those apartments so that your vote you're get. But like you say, the Dallas police come out. The property may be within the city of Dallas. There is a little piece of the city of Dallas that's in Denton County. It's a very small piece, but there's a piece. Yeah, I'd have to help you look up the property, or at some point in time, you're more than welcome to email me about that. I'm happy to look it up and see if I can find out what the issue is there. But is there someone to report? Is there somewhere to report a lemon for the rent on a rental house? Yelp is the only thing I know of, but we talked about that earlier. But do you know anything else, Francis?
For a rental?
Yeah, for a rental.
Like a lemon law?
Yes.
No.
Yeah, or
No,
place to,
you have to follow what is available, and that's, make repair requests, contact code compliance. There's really no like lemon law for housing, especially rental
um,
housing. It's, I mean, if you might be a different situation if you bought the house and it's a lemon, but even then it's not called a lemon law. It would be something else.
in Denton, Christy says in Denton, there's the they're posted the contact email on the website for Denton County. Quick question: can you request a specific space I identified to you? I've seen complexes that will just put a handicap pole, but no specific apartment number listed in the space.
Yeah, you can ask for that. So keep in mind for accommodation requests, you can ask for anything that you need. Now, after you make that request, like say the reason I say make any requests that you need is the apartment might say, okay, we'll do that for you, and put in a sign for a space that has your unit number on it and says only that unit can park there. Now, if they don't do it, or if they say no, or they just sit on your request and don't take any action, that's when you need to get an advocate, and you can call us and we can get involved. Then we go to the analysis step, because what you asked for may not be the most reasonable solution. And that could be for a number of reasons. There could be another, there could be another way to get you what you want that suits your needs. And some of that could be dependent on how they assign parking in the first place. Because there's a big difference in, places where there's assigned parking versus places where it's kind of a first come, first serve. You park, there's tenant parking, and you can park wherever you want in the lot, in the tenant lot. So, then we have to do that analysis to find out, in this circumstance, what best meets your need. But
Lindsay,
by all means, ask for what you need, because they might give it to you without any hesitation.
um, Lindsay asked, if a tenant has to take time off work to be home for the landlord to see the property's issues, those issues are deemed, and if those issues are deemed valid, can the time missed be repaid by the landlord?
So in Texas, with repair issues, or for any valid reason, the landlord has to enter your rental. There's no requirement that you have to be there. And so if you choose to be there when they come in, that's your choice. But, there's no absolute like right to be there. They can enter the rental anytime they want, and you don't need to be there. So I hope that answers it. Because if that was something that at the first apartment I had when I moved to Texas, I wanted to be there when they entered my unit, because I had pets and I didn't want my dogs like racing out the front door, which they were known to do. And so I told them I wanted to be there whenever they entered my unit for anything, but that was my choice. So I had to take time off work, right? So no, I don't think you'll be able to I don't think you'd be able to get reimbursed for that.
Okay, two things. Number one, can I get you to advance a slide one, and then there is in the there's two more questions real quick in the Q&A. One says, what is a risk fee when leasing?
A what?
A risk fee, RISK fee.
I have never heard of a risk fee before.
Could that be a way of them getting around a pet deposit for trying to get around a pet deposit for a emotional support animal?
My best guess is that it means you're a riskier tenant, meaning maybe you didn't have a great credit report or credit score. And so they ask you to pay more like deposit, maybe because you're more risky. But I would want to know the context of it before I could answer that. But my best guess is you're a risky tenant because your credit score isn't as high as what they'd like to see. I don't know.
Um,
Ooh, but it was through Dallas Housing, like Dallas Housing Authority?
well,
I don't know.
interesting.
I would probably need to talk to you more offline to figure out what that was.
Yeah. Okay, like I think, I'm going to go over the CEUs. We're at the end of the time. And so I want to go over the CEU stuff for those of you that are on for CEUs. Today's webinar, we're providing complimentary CEUs for licensed social workers and licensed professional counselors that are licensed in the state of Texas. We're also providing a certificate of attendance for anybody who would like one. Please note that the rules are the same, or the guidelines are the same for each of these in order to get one. And I've had people tell me they've been able to use the certificates for other licenses in Texas or license outside of Texas. But please know those are the only two people we're set up to provide for. We can help you with those, but we couldn't help with any of the other ones if they refuse to take them. Today's webinar is with 1.5 hours of CEU credits. You must have completed the entire webinar and the Q&A in order to qualify. You must also complete, very important, the Google evaluation survey. It should give you an opportunity to go to that, ask you if you want to go to that as you log out of Zoom today. If not, you will also be receiving that link in the follow-up email that will go out tomorrow. The Google evaluation link will be available until 5 p.m. on the 3rd of November. And please give us about a month after that to give us enough time to get all the certificates out to you. And there you go. Francis, very, very, very informative, very good, great stuff.
Oh,
Kia, I
of
got
course.
your information on the voting thing, and I'm just not, that just baffles me just a little bit. So I'll have to think about that and try to, or if you could email me, that would be great. That way, I'm traveling right now, so I don't want to forget to get back to you. So if you could email me that question, that would be great about your voting.
And everybody remember we have a tenants rights clinic on November 15th, and you can sign up to, if you want to discuss your specific issue that you're having
Yes.
and get some information and help. That's what the clinic's for, to bring us your issues that you're having right now. And, we could give you some information and advice on how you can handle it.
And just so you know, the clinic we do in the meeting format, this is done in a webinar format. Well, I guess we do, but we have people sign up. You got to sign up. There's two different tickets. One is to actually present and talk about your case, and the other one is really just to observe. But if you sign up to talk about your case, we're going to put you and let you open up the mic and let you actually describe the case and ask questions and that kind of thing. So the clinic is an interactive format that we do let you talk in that one. It's pretty hard on these webinars with as many people as we get to open up the mics for individuals.
Yeah, and I have to say, like, our last two clinics, we have gone the full like hour and a half because it seems like people are having a lot of housing issues right now. I don't know what's going on with the housing market, but I know our last two clinics have been like jam-packed. So even if you don't have a case to present and you want to just listen to what's going on and how to handle different problems, you could sign on, like Marty said, as an observer.
Yeah, and they've been really, I mean, there's been some really good stuff on the last few clinics we've had. So please, and help us spread the word about those. We will not be doing webinars for housing in November and December. There's just a lot of other stuff going on. So look for us for the webinars, hopefully back in January, but we will be doing the clinics in the clinics both months.
Yes, so we'll have clinics in both November and December. We already have the November date. And I'm sure, Marty, you have the December date already, maybe.
I don't have it right in front of me, but
so those will be available for folks if you need housing rights assistance.
Yeah, very good. Francis, thank you so very much, as always.
Thank you, Marty, for organizing everything.
Absolutely. Thank you all. And you all have a wonderful day. And I hope you all that decide to go to JP Court come out winners. Thank you all.
Yeah, and send me an email if you need, any kind of help with trying to figure out how to have the best evidence to put forward in your case.
And please disregard my discussion about going bird hunting in your neighbor's apartment. I'm sorry. I'm so sorry. That's terrible. Okay. Thank you all. Y'all have a wonderful day.